today today we're going to talk about family preparedness. If you've joined us for any of our previous webinars where we've talked about this, we've really been talking more about the planning side, what to do to make sure that you have proper planning in place for when you or a loved one passes away. Today, we're really going to talk about the other side of it. What happens once someone ultimately passes away? What is the process like on the other side, so that we have a better understanding of what to expect? But also, I think that helps to understand the importance of some of these key steps that we do in the planning process. All right, let's move ahead with the slides here. So again, in the planning that we do with people, we spend a lot of time talking about the importance of having a plan in place. And it's really interesting that so many people we work with don't have a plan fully executed, meaning they've talked about it with family, they have an idea of what they want to do, but they really haven't gotten to the point where they've taken the steps to make it be legally binding. So they've gone through the process of establishing a will, working with an attorney to make sure that all of their assets are titled appropriately, beneficiaries are correct, kind of making sure that all of those pieces match up. The first thing that we really want to talk about is this estate planning piece very briefly. The importance is to really make sure that you are prepared for when an event does happen. So whether this is you going through this process or helping a parent or another family member saying, let's get your affairs in order so that we really know what to expect when the time comes. And so I've noted here that we want to have proper planning complete. That's something that we can help you with. You'll see here there's a document that we use that's our family preparedness kit. That's a place where we can pull together all of the information that anyone would need to know about your financial life if something were to happen to you. But then we take that a step further and we say we want to make sure that you update the legal document. So that's meeting with an attorney and having a current will in place. And I say current because a lot of times we'll meet with people and they'll say, yes, I did estate planning, but it's been 10 years or 15 years or 20 years, and circumstances have changed in life. Not only have your circumstances changed, but we also have laws and other things that will change over time that make it necessary to review and update these documents periodically. So if your circumstances have changed, or if you haven't had your will reviewed in the past, I would say 5 to 7 years, I'd really encourage that to be something that you put on your action list for things that you want to revisit when we think about that estate planning side of life. Current beneficiaries. This is one where we put it on here because it's really important to make sure that your beneficiaries reflect your estate planning. A lot of times people set up accounts back 10, 15, 20 years ago and listed beneficiaries, but for whatever reason, those beneficiaries have changed over time. So one, we want to make sure that your beneficiaries are current, but two, we want to make sure that it supports the legal planning that you have in place. So we're going to talk about that a little bit more later, but if you haven't revisited the beneficiaries that are listed on your accounts, we want to make sure that that's something that's on your list as well. Proper account titling is really important when it comes to estate planning. We're going to talk a little bit later about tax implications of estates of certain sizes for Washington state, other states that you might reside in, and then at the federal level. But we really want to make sure that your assets are titled appropriately so we don't undo any planning that was done in the legal planning side of things with your attorney. Other things that are just really important if you have small children or people that are dependent on you, and pets are another thing that people frequently don't always think about. What's going to happen if something were to happen to me and the animals that I have? So we want to make sure that you have a plan for all of that. And then let your loved ones know what your preferences and wishes are, or if we're talking about you helping other family members or parents plan for their circumstances, make sure you have a good understanding of what their game plan is so that it doesn't come as a surprise down the road. So I noticed there's two documents that are shown on the screen here. with the Family Preparedness Kit, which outlines everything and kind of lets you organize stuff. But we also have on there it's an asset map, and this is a one-page summary that shows your full financial life. And so this is a really great tool, not only for the planning side of things, but also when you're sharing with your loved ones to say, hey, here's how everything's laid out. And so when something does happen, someone who's listed as your executor or personal representative will know where all of the accounts are and know where to go to start the process of saying, how do we look at distributing some assets as part of your estate settling? All right, immediate actions. We are most frequently one of the first calls that clients make once someone's passed away to just say, what do I do? Because there's this triggering event where we say, I need to take action. And so we want to start with what are the most immediate actions that we need to take place and consider. Because it all feels like it's happening in a bit of a vacuum, right? This is a very emotionally charged time in life. There's a lot of confusion, a lot of different family members that could be participating in conversations. And so it's really just who is going to take steps and what do those steps look like is what we're going to focus on here. So the first thing that we're going to say is that we're going to have you request a copy of a death certificate. This is first on the list because this typically happens when you're going through the process of working with the funeral home. They're going to say, how many death certificates would you like? And it's hard to know in that moment how many you need. What I'll say is that most institutions are going to require one. So if you or a loved one that you're helping settle their estate has a lot of financial assets spread at different banks, different financial institutions, then you might want to request a handful of copies so that you're not stuck in a situation where you have to go and request additional ones. And the reason why that's important is that it takes time to receive the death certificate. It's typically a 2 to 3 week time period from when we're requesting them until you receive them. So our suggestion is that you request a minimum of 3 copies, but as I said, if there's a lot of assets that are held out there in various locations, you may want to request a handful more. So that's listed as at the top of the list because that typically happens before you've done number 2, which is contact trusted professionals. So we want to make sure that you're in communication with the parties that will be involved with settling an estate. And so that's going to include attorney, financial advisor, and an accountant. And we're going to go through sort of how each one of those are involved, but it's just and important to know that kind of all of those parties will be part of settling an estate. If you haven't already done it by this point, that's locating will and trust documents would be the next step. And that's really where that attorney can come in as a helpful resource because they'll have copies of everything that's needed if you're unable to locate copies for the loved one that you're working with. We frequently have copies of these documents, at least the trust, for clients that have trust accounts, but we can also help you store your will in your document vault. So if you want to have a place where you can say, here's where everything can be accessed, then we can definitely assist you with that. The next step is notify financial institutions. This is an important one because it is, the clock starts ticking as soon as someone passes away. And so as soon as financial institutions are notified, it will freeze the assets because the individual associated with those accounts are no longer living. And so that's where that clock essentially stops on their date of passing. And it's important that you notify companies for many reasons, but it's also important that you recognize that anything that's happening with those financial institutions will cease as soon as they are notified. So I'll talk about accounts that are held with us just as an example. And so if you are a co-owner of an account with someone who passes away and you notify us that they have passed away, if they're the primary account holder, meaning that the account is tied to their social security number, any assets that are in there, any distributions, anything that's going on with that account is going to need to be placed on hold until we can process a distribution that that's appropriate for that account based off of the will, the titling, the death claim. And so there's the death certificate. There's a process that we're going to have to go through in order to release those funds. And so the same thing can be true at bank accounts. And so the reason why I'm spending a little bit more time on this is to make sure that people know that there can be circumstances where it is beneficial to have assets in your name singularly versus joint if there's a concern about how am I going to have access to funds if my partner were to pass away. The next one is inform current and previous employers. So again, there's going to be a time clock that stops when someone passes away. And so we're going to have to notify that there's no longer compensation coming from current or previous employers. And if that person had a pension, does the pension need to be adjusted because they're no longer living, but there was survivor benefits on it? If it's a current employer, is there going to be a payout from a life insurance policy that the employer held? Are there other distributions that are going to happen from the employer? And so that's one that needs to be on the list. And then we have notify government entities. So on there is Social Security Administration and Veteran Affairs. So this is another one that sometimes catches people off guard because, again, we have that clock is going to stop when someone passes away. And so for some of these benefits that are paid in advance, meaning they pay for the month ahead as opposed to the month behind, those benefits not only stop, but there'll be a pullback of income that was distributed if it was paid out ahead for the month ahead. And so we just want to make sure that people are prepared to say Social Security is going to pull back the payment that was made to a deceased person. And so if there's other distributions that are going out of that bank account, if there's other things that are resettling from an estate standpoint, we just need to make sure that we're not counting on that money because it is going to be pulled back. So the big thing on this slide is to just say, we want to make sure that we're contacting trusted professionals. We want to notify financial institutions and then have a good understanding that everything that's associated with that individual will be frozen until the death claims are able to be processed. And if you remember on the previous page, one of the things I said, or at the top of this, one of the things I said is that we need that death certificate before we can do anything. So accounts are frozen, it's 2 to 3 weeks before a death certificate is received, and then we can start processing the death claim. So there is a time period where everything will be on hold, and it's just sort of a heads up that that's an important piece for you to be aware of if you're going to be in the circumstances where you're dependent on money coming to you from an account of a deceased person, or if you're communicating it to someone who's going to be a personal representative or executor that's responsible for settling your estate. So I will pause there real quick. If you have any questions, there is a question and answer box on your screen, and you can type anything in throughout the whole presentation. But if there's anything that immediately comes up as a question for this slide, I will go ahead and pause before we move on to talking about the more legal side of settling the estate, which is known as probate. Okay, great. No questions so far. So now we're going to dig into probate. As I mentioned, probate is the process where we have to notify the state that an individual has passed away. We're going to provide them with additional information from the will that states who the personal representative is for the estate. If there is no will, then there's a different process that we can go to where you can say this individual is deceased and I'm stepping up to be the one to settle their estate. But again, really important to make sure that there's that legal document of will in place so that we can simplify this process. Before I go through all of these steps, I will say that people frequently ask, how can I avoid probate? And probate is just the process of going through appointing someone to act on the behalf of the deceased. So it doesn't mean that there's not taxes. It doesn't mean that there's other things that are in that need to be considered. The only way that you can avoid this is if your estate is, if you have a small estate, which is $100,000 or less in Washington, and then you can use a small estate affidavit. Otherwise, this probate process is a process that everyone's going to need to go through. And so it's not, it's just the time consuming part, I think, is why people like to avoid it. There can be some small attorney fees, but in general, it is the process, and it's something that most estates are going to go through. So as I mentioned, your will would list who you want your executor or personal representative to be. That person submits the documents to the court, and then the court gives them a legal document that's called letters testamentary, which gives them the power to act on behalf of the deceased. So they are now taking on the role of stepping in and saying, I am going to be responsible for everything financially involved in settling this person's affairs. So it's really important that you consider who you list as your executor, not just because you want it to be a responsible person, but also it can be a challenging person or challenging place for that person to be if there's a lot of family members, because this is the one person that's in charge of all of it. And if you have a lot of family members with big opinions and feel like things should be happening in a way different than they are, it can be challenging. So I just like to always remind people that being an executor is not a glorious position. It can be a challenging position to put a family member in. And the more you communicate to your family who is in charge, why you put them in charge, but also the time frame that it takes to do all of this, I think that that's helpful. Because the biggest tension that we see created is that people feel like they should be getting their assets distributed to them more quickly than they are. And as I've said, it's a process. There's courts involved, there's documentation involved. And so it's weeks to months that all of this takes place. And so setting expectations for family members, I think, can be helpful so that the person that's put in charge of settling the estate doesn't have the tension that could come from family members feeling that it should be handled differently. So once that person is appointed, they then are responsible for giving notice to anyone who is going to be receiving funds from the deceased. So anyone that was listed as a beneficiary on an account, in their will, and then we also have creditors. So part of the estate settling process is that we have to notify people that the individual has passed and give creditors an opportunity to file a claim against the estate. So back to what I said a minute ago, it is going to take time to settle it. There is a time period where we cannot distribute all of the assets, even if we wanted to, because that requirement of the creditors being able to have a specific period to file a claim has not been met. And so again, we would instruct, whether it's us or an attorney, would help the executor understand you cannot distribute all the assets, because if a creditor comes back and says, hey, I am owed money from the deceased, and that could be a medical bill, it could be a loan that exists, there could be all sorts of different circumstances. You have to then go back to all those beneficiaries and say, hey, we need to get some money back in order to pay those creditors. So it is an important step, and again, takes time before it can completely be closed out. Inventory and appraisals, this is one too where I mentioned that one-page financial summary that we have for clients can be really helpful to say, we need to know where all of the assets are, and we need to value all of them as of the date of the individual's passing. And so everything is going to have a value based on that date of death. And that is important because that resets that clock that we've referenced before. So clock stops when an individual passes away, and then that date going forward, it starts a new clock. And that'll be important when we talk about taxes in a little bit. The other thing that the estate is responsible for before all of the assets are distributed, I already mentioned payment of debt that is outstanding. There's also going to be taxes that are owed. And so we want to make sure that, again, there's money in the estate in order to be able to pay those taxes. We're going to talk about taxes because that's one of the things that I think clients ask about the most. having a better understanding of how taxation works upon their passing. So I mentioned that taxes are typically owed by the estate, and there'll be a final income tax return that needs to be done for the estate, regardless of when the assets are transferred, because remember I said that clock resets when the individual passes away. So anything that's earned on assets before they're distributed to the beneficiary, there's going to be taxes associated with them. And there could be additional taxes besides that. So you'll see that second bullet point there. The state of Washington has an estate tax threshold per individual of just under 200,000. And so what that means is that if you have an estate over 4,400,000 and you have a partner, you each get an exemption of 220, roughly 2,193,000. So we want to make sure that if your estate is in excess of that, one, you're prepared for estate taxes that are going to happen at the state level. But two, we want to make sure that everyone keeps their exempt amount protected. And what that really means is that we don't want to necessarily transfer all of our assets to our spouse in that case where we're over 4 million. And so the reason why that is important is that we want to protect that 2,193,000 per individual. So let's just say that we have a couple and they have a $5 million estate, and they've set everything up so that when they pass away, all of the money goes to their spouse, so that their spouse is protected and that their spouse has the money for the rest of their life if they need it. Well, if that is executed where everything shifts from joint ownership to single ownership, we've now moved 5 million over to a single individual, and they only have an exemption amount of 2,193,000. So when they pass away, anything in excess of that, so in this case, north of 3 million, is going to get taxed by the state of Washington, where we could have protected over 2 million of that from being taxed if we had sheltered it at the passing of the first individual. So that's a really complex thing to process, but it's highlighting the importance of needing to make sure that you've updated your estate planning documents, because an attorney is going to plan for that in your documents. That's where you'll hear things like a credit shelter trust or other trust work that says, I'm setting up a trust at the passing of one individual to protect their exemption amount. Their spouse can still have access to it during their lifetime, but we need to make sure that it doesn't get transferred ownership fully to the surviving spouse because of the future taxes that it could cause. So it's a much bigger issue at the state level. You'll see the next bullet point is the federal level has a much higher exemption of over 13 billion per individual. So most people look at that and say, okay, that's not something that needs to be concerned about. I did note that exemption amount is set to sunset in 2025. So in 2025, we'll know what 2026 exemption amounts might be, and that could result in us having to revisit plans or do some updating for individuals that want to make sure they have protection at both the state and the federal level. And then the bottom bullet point is that assets may be taxable regardless of the size of the estate. So thus far, we've just been talking about estate taxes, and that's because of the size of the estate, but we're gonna in a minute talk about the different types of assets that will transfer and how some of those will cause taxes and who pays the taxes. So that's going to bring us to distributing assets. And I really encourage you, if you're having questions as we're going through this, to pop some of those in the question and answer box, because I know that there's a lot of complexities to these. And if your circumstances are such that you have questions that are beyond the high level ones that could benefit the whole group, put your question in there and we'll follow up with you to make sure that your question gets answered, or schedule time so that we can talk about your circumstances specifically. Okay, so by this point, we've gone through the process of deceased has passed away, a personal representative has been appointed, they have the death certificate, they have the letters testamentary, they have everything that they need to say, we're ready to start settling the estate. And so this is the process of where assets are going to actually change ownership to the individuals that you listed, either for certain accounts, they're going to transfer by title. So there you see jointly owned assets. So that means we'll transfer ownership to the other owner or owners of the account. Or for individual assets, there's two ways that assets are going to transfer, either by beneficiary designation or through the estate. We're going to talk about that on the next page. And so this is back to that joint owned assets. We want to make sure that the ownership titling is appropriate for what you ultimately want to happen. And so we don't want to necessarily default to saying, hey, I just want my spouse to inherit the full account if I pass away. It could be that they're joint owned assets, but we want to protect the 50% that is tied to each of you, so that if you passed away, it doesn't automatically transfer to the other, and helps us to protect that state exemption that I referenced. All right, so we're going to talk first about beneficiary designations. This is one that I think people are familiar with. If you're on this call, we've talked to you about your beneficiaries, so hopefully it's not something that is a new concept to you. But what this is saying is that we are adding verbiage to that account that will state who inherits the money directly, regardless of what your will states. I think that's a really important point, because I mentioned at the beginning of the call, we want everything to match up. So if you've done your estate planning and your estate says everything's supposed to go into a trust and distributed from a trust, then we need to know that, because we could have accounts like a retirement account, an annuity, an insurance policy, something that we've listed beneficiaries on it where it's going directly to an individual. And so if we have individuals listed on your beneficiary designation, that will supersede anything that's listed in the will. So we want to make sure that everything matches up. But beneficiaries are a really effective way to transfer assets and minimize the process. So if your will says everything's to go to my 3 children evenly, for these type of accounts, we want to list your 3 children. We want that to go directly to them. 1, it simplifies the process. 2, it's going to help with some of the tax management of things. And then there are circumstances like insurance policies that transfer tax-free. So we want to make sure that those individuals are getting that money directly. So beneficiaries can be added to retirement accounts, annuities, insurance policies, or if you have accounts that are individually or jointly owned, you can add beneficiaries to them with a designation by including a transfer or payable on death. And so what that means is it's just saying that if both of us were to pass away, or one of us was to pass away, if you're a single account owner, then it automatically passes the money to the beneficiary. The other thing that's important to consider about this is, I mentioned that there's the process of settling the estate. Sometimes you need money in the estate in order to be able to pay creditors, have money to fix up the house to sell, whatever it might be. And if you've transferred all of your money by beneficiary designation, then the money is now distributed to all of those individuals. And that could create a problem where now, again, in that example, if you have 3 children, one of them is the executor who's trying to fix up the house, or needs money to do whatever to get this estate settled, but there's no money to do that. So again, we just want to make sure that we're being mindful of trying to balance simplifying assets transitioning, but also not doing it in such a way that that leaves no money in the estate if there's funds that could be needed. So the next bullet point here, we talk about each beneficiary makes an election on how they want to receive the funds. This is an important thing to understand because it gives freedom and flexibility. So if you have 3 kids, they do not have to be in agreement. They can each make their own decision about their third that they're inheriting. So clients will frequently ask about that. Does everyone have to get in a room and decide what's happening? No. beneficiaries from these type of designated accounts get to make their own decisions about how they're going to receive the funds and what that looks like. In the circumstance of the next one that we're going to talk about is when it passes to the estate, your executor is the one that's responsible and makes those decisions. So it's not a group decision, it is what the executor is doing. We're going to talk a little bit here about retirement accounts specifically, because this is one that carries the most taxation, and also I think people have the most questions on. So if you have a retirement account, so that's individual retirement accounts, a 401k, any type of tax deferred account for retirement purposes, and you are over the age of 73, required distributions are happening on an annual basis. And so when someone passes away, if they're in that required distribution phase, that required distribution still needs to be met for that year. And so that will need to be distributed. And then the individuals that are inheriting the retirement accounts have 10 years to distribute those assets. So by the end of the 10th year, 100% of that account needs to be distributed to each one of those beneficiaries. So what that's doing is it's allowing them to spread out taxation over a 10-year time period. It does not mean that they have to distribute a tenth of it every year, but there is a minimum amount that would need to be distributed. So this is one that comes back into those tax planning opportunities where if someone's circumstances, they could say, well, I only want to take a minimum distribution over the next handful of years, and then I'll take a larger distribution at the end. They can structure it that way. However, what we're finding is that most people are trying to do it in a more even way, so they're not having a balloon payment with a lot of taxes towards the end of that piece. So let's just go back over that one more time, because I think this is one where people do have a lot of questions about how does the taxation of that work. So you've never paid taxes on this money. You've accumulated it over many, many years. You pass away. Whoever is receiving the money that is not a spouse has a 10-year time period to distribute those assets. So there's a lot of tax, tax considerations in receiving monies like that. And we give guidance to clients who are inheriting money from people we've worked with to say, let's make sure we have a good understanding of your tax circumstances and how this is going to impact it. And it's different than it used to be. You used to be able to take distributions for inherited retirement accounts over your lifetime. That changed in 2018. And so it's making the tax planning side for these type of accounts are getting much more attention, because you might be in a lower tax bracket than your beneficiaries are. And so that is a big consideration as far as how do we want to be getting money out of these accounts in a more tax efficient manner, either during your lifetime or at your passing. And then the only other thing that the point on this is that if people are inheriting this directly, so whether it's a retirement account, an annuity that has tax deferral, the taxation is rolling to them. And so it's just an important thing to be considering as far as how are we strategically thinking about some of these tax pieces and not creating a large tax burden for the next generation. A question did come in about I mentioned that the 10-year rule does not apply to spouses, and that is correct. If you're a spouse inheriting an IRA, it becomes your IRA, and you then have distributions that are paid out over your life expectancy. So you will have required distributions that get recalculated on an annual basis. Okay, so that was if accounts are passing by beneficiary designation. And so a lot of times people will say, even if they have beneficiary designation options, they'll say, I just want to pass to my estate. So let's talk about what happens for assets that pass through the estate. I've already touched on the point that who is responsible for managing all of this, and that is the executor. The first step is they will establish an estate account. So whether this is your money at the bank, they're going to need an estate account. Whether it's your investment accounts that are held here with us, they're going to need an estate account. Everything has to pass to the estate. And so we'll see assets will get moved to these estate accounts. And then once we've gotten to the point where we're feeling like we're close to being able to settle the estate, they'll start to talk about distribution options. And the guiding document for how this money is distributed is based off what your will states. So if you have charitable gifting listed, if you have a handful of family members, whatever you list in your estate, the executor is responsible for making sure that that's how the money is distributed after they've met the requirement for notice to creditors, all debts have been paid, and all taxes that are owed have been paid. So again, this whole thing can take quite some time, especially if you have illiquid assets that are going to pass through this estate process. So think about your house, car, any other real estate or other holdings that are not going to be liquidated immediately. There's going to be a time period where those are going to be estate held assets that beneficiaries are not going to have access to the full amount. And I say the full amount because there will be times where it makes sense to distribute a portion of the assets and hold back the balance. So let's use that example of a home. A lot of people in this area, their home is their biggest asset. And so it might take time to clean out the house. It might need some maintenance or updates. There could be a process that's going to go through that could be a 6 to 9 month time period before that house is sold and funds are put into the estate account from escrow. If the individual also had bank money, non-retirement investment accounts, all of that money will be put into an estate account in a matter of a month or two. And so it could be that a first round of distribution happens at that point, 3 months in, again, at some cadence to say, I can't give you all of the money that you're entitled to, but I'm going to do an initial distribution, this is the executor, in order to just have some money distributed. And that can be helpful for family members where I mentioned before that some of the people feel like funds should be distributed more quickly than maybe they are, not understanding that it is a whole process as the executor is going through to do this. So again, I share that only because I think it's helpful to communicate to family as far as for the executor, one, they need to know that they're signing up for a nearly year-long job. And then two, for other family members to know that it's not necessarily going to be a quick process for distributing all of the assets. So down there I just listed, timeline for an estate to be settled. It's typically about a year. There are circumstances where it is shorter, and there are definitely circumstances where it's longer. If the estate remains open, then there's annual filings that need to happen with the court. And so there is additional documentation that can be provided to the court, but also to other beneficiaries if there is a reason that it is a prolonged process. And again, I think that's just a good communication transparency point for the executor to make, to say, here's the reason why it's taking longer than an average time period. So again, we're talking about assets have been distributed, everyone's received their share, whether they're receiving it as an inherited account that goes directly to them, or it's been a distribution that's happened directly from a trust or estate account. Once it's all done, there is final accounting that's filed with the court to just document on the date of passing. If you remember, we started by listing the value of every asset on that date. And then we show documentation that says, here's how the assets were distributed. And then once the court reviews that, they will sign off at it as the estate being closed. And that relieves the personal representative of their duties. So it is a legal process, and there are steps along the way that need to be met, and the estate does need to be closed out by the state. I mentioned that only because we've had people that haven't necessarily gone through the whole process start to finish. And that's where at the beginning I said, you're going to have likely an attorney involved, you're going to have an accountant involved, and then you're going to have whoever is responsible for help giving guidance on the financial assets where they are, be involved in the process as well. And while I'm on that note, I think that's another thing that's a consideration for people is that one-page summary that shows where all the assets is super helpful to be able to provide guidance to the personal representative to say where everything is. It's also really helpful in your advanced planning, so ahead of time planning, to say how many of these boxes need to be separate. Because if you think about it, if there are 12 boxes on, on a page like that, that means that when you pass away or when your loved one passes away, there's going to be a process for every single one of those boxes. And so we frequently have people that over time have said, I like to diversify where assets are held. I like to have, things in different buckets. I think there's a lot of value and benefit to that, but over time, it might make sense to say, can I replicate some of those things in not so many locations? So one of them that comes to mind is, bank money. A lot of people are looking to say, I want to have bank at multiple institutions for FDIC reasons, and absolutely appreciate that. And that makes a lot of good sense from a protection standpoint. You also just need to then keep in mind that when you pass away, if you don't have beneficiaries on those accounts, then it's going to be a process of needing to go through the full estate process for your representative to each one of those banks. So that's more of a consideration of for different types of accounts, it may make sense to have them be distributed by beneficiary as opposed to the estate, or vice versa. So that's another thing that we can help look out for you, just to say, is this set up so it's going to be the most efficient down the road? And that's also something that's true for people while they're living. So I know that some of you on this call are thinking about your parents and what could be coming down the road for them. And if they have a lot of little accounts sprinkled all over the place, is that something that you could help them consolidate or simplify so that it's less challenging down the road when the time comes that you have to be tracking all of those accounts and processing them? So we're coming to the end of the high-level conversation. I know that there's a lot of things that we have not covered, only because there's so many different directions that these things can go. So this is really more to get you thinking about your own circumstances. Be prepared to ask questions about your own planning as well as your family's planning, either when you meet with us, or like I said, if it's for another family member, you want to just ask questions about, hey, I know you mentioned that I'm your executor, but it'd be really helpful if we could sit down so that I could have a good understanding of kind of the financial picture that you have and be prepared for what could come down the road. And we obviously can help you with your financial picture. That's where that one-page asset map has been really helpful for clients to pull together a snapshot of everything. And if you have not completed your planning, take that to the attorney to either complete it or review what you have in place to make sure that it's appropriately outlined. So again, it's really fairly straightforward that the best route is to have a plan, but not only having that plan, but take the steps to complete it into a legal documents. And we've been mostly talking about the financial side of things, but I think it's also important that you have your other wishes outlined. So that's going to be healthcare directives, disposal of remains, really thinking about all of those different things in your life that you want to make sure you have your wishes clearly stated for your loved ones. The middle of this does take time to grieve. We do want to be contacted as soon as someone passes away so that we can kind of start that process where there are implications that it's important that it's done in a timely manner, but it's also that not everything needs to be settled right away. as I said, the whole process can take up to a year. And so there really isn't a lot of urgency to take action immediately, unless there's that kind of the situation where you're saying, I need access to other resources. So if that's a concern for you, we'd rather have that be part of that plan ahead scenario so that you can take time to grieve, and that we're not having to you kind of go through all of these intense process of moving things around and getting things settled while you're in the early stages of grief. Have a support system. We really are here to support you, but it's also great that you have family members that are aware of what needs to be done, so that it's not a surprise to them. So we are willing to host family meetings where we can have some conversations, whether it's the specifics of your financial life or just saying, hey, at a high level, here's what is going to happen down the road if or when someone passes away. Let's make sure you're prepared for what your role is and what you should expect. Because I think that's the other thing is, as I said, people have different views on how quickly things should be happening or what the process is. So that's good to understand. And also, we talked quite a bit about taxes. I think that the taxes are the thing that actually catch people off guard the most, especially now that the beneficiaries only have 10 years to distribute those IRA or retirement accounts that have a lot of tax deferral built up in them. It can be something that makes it challenging for them to navigate if they're saying, I now have all these additional taxation that I wasn't prepared for. And then, like I said, the last thing would be reach out for help. Unfortunately, we do this a lot because we're a second generation business. A lot of the planning that we did 40 years ago is now getting to the point where we're passing it on to the next generation. And so we have a lot of experience in this space. We know a lot of the challenges and can help simplify process for you, but also give direction. So I will just say, when someone passes away and their beneficiaries come to us, I mentioned we need, notify the companies, provide copies of the death certificate, request death claim paperwork. We do all of those things for them and help them complete it. And so this really is a space where it is advantageous to lean on professionals. So whether that's the advisors from that support the accounts, the tax advisor, the attorney, this is the space that we all have expertise in that most individuals do not. And so it is one of the rare places where it's really just do not try and figure it out on your own. Let's make it be simple as possible and help give you guidance through it all. Okay, we have had some questions come in. So if there are more, please keep them coming in. But some of the questions are just where to get started. And so we do have a family preparedness workbook, which is meant to help you think through the different phases of your financial life that you should be preparing for. So as a follow-up, we'll send that out to all of the participants. I know many of you have already completed it or started it. It is quite comprehensive, so I will give that disclosure that it can feel a little bit daunting when you pick it up. So if that feels like too much to get going, because it's everything from medical information that could be relevant, passwords, where are they kept, legal documents, it's very robust as far as what it covers. So it might feel like a little bit much to dig into from the start. So if that is overwhelming, I would say let's make sure that your one-page financial summary, that asset map that I showed at the beginning, is complete. And we go through that together to just make sure you understand, okay, as everything is set up right now, here is how that is going to be distributed at your passing. And then, so you can have a good understanding of that. And that process will help us identify if there are gaps in your planning. So, so start with us, and then we do have attorneys that we work with, and we have quite a few that we work with. We will match one that's appropriate for the complexity of your situation. Some are much more simple, and there's others that can have a lot more challenges depending on your asset level, the type of assets you have, but also your family dynamics. This is one where family dynamics are a really big part of this planning process. And if you have dynamics that are going to cause additional planning to be done, we really want to make sure that we're digging into that and not avoiding it. Another question that comes up is to say, when I mentioned about accounts getting frozen and access to dollars, how much money should be set aside for that initial period where money might not be freely flowing? And so that's one where it comes back to this idea of, do we have an emergency fund? So if something were to happen in general, even if everyone is living, do we have access to cash where it's not going to disrupt our financial life? And then this would be an emergency situation of saying, okay, great, I know there's going to be a period of time where I'm not going to have access to money. How much should I have in that account? And so that one is really, the number is personal. I said everyone has their own number. And so, we can definitely work through an exercise to say what feels right for you. But I would say for people that are already retired, I like to have, 6 months to maybe 12 months of money that's easily accessible without any ramifications. So bank account is a great one for that, especially now that the bank's paying higher money, or having it in something that's not a high risk investment option so that we can, kind of access it in the short term without any challenges. Another question that came up as far as the planning document that I shared, the Family Preparedness Kit, we do have an electronic copy where you can fill it in and save it that way, or we can mail you a hard copy if you prefer to have it be something that you can kind of have printed out and just periodically write things in as they come to mind. So both are an option for that. And then another question that came in is as far as do we have attorneys that support other states? And the answer is yes, not all states, but for most of the states where we have clients that either their primary residence is, so we think about that as being Washington, Oregon, Idaho, California, Arizona is where we kind of have a cluster of clients with primary residence. So if you're out of state and need an attorney referral, we can absolutely help connect you with someone. And then, another question is that came up is just that, where do I start? And so I know that it's a challenging thing to do. And so start with us. I'd love to, if you have questions about your own planning and you want to sit down and just say, help me identify the things that I need to be thinking about. You can schedule a time to do that, just a meeting for that specifically, or we can talk about it in your next review. Because a lot of times the things that people, the obvious things people have covered, but there's other considerations that maybe myself or an attorney or someone else looking at it would see that maybe hasn't come to mind for you and your family. So again, it's one of those things where I don't recommend trying to, figure it out on your own. Really lean on those professionals that you have in your life, because we have the experience and benefit of seeing a lot of other people go through these circumstances. So you learn a lot through that process. And then, an example of that is we live in a very digital world these days. And so for the person that says, is there an electronic copy to the planning document? Yes, there is. But if we do an electronic copy, where does it live? How do people know how to find it? Or if we think about your bank accounts, we have a lot of people where they say, my spouse is the one that managed all of our bank accounts, and I can't get into any of that information because I don't have the online access. And so there's a lot of things that are just beyond those kind of obvious top of mind things that used to be that weren't the same a generation ago, because now we live in a much more digital world. Even accessing someone's phone, that's one that we've heard a lot too, of just I don't need any information off of that, but I really would like to have the pictures. So just those things that we always want to be evolving and considering. So we can help you think through all of that and then get you to a point where you've got a good game plan and are ready to take the next step with an attorney and connect you with an attorney when that time comes. So I think that's all the questions that we have. What we'll do as follow-up is we will send out, like I said, a link to the family preparedness document. So that's one where you're going to be able to access it electronically. If you would like to have a printed or hard copy of that sent to you, you can just respond to that email and request that. We'll also include a link for if you want to schedule time to meet to talk about your own circumstances, just do a review of your estate planning. There'll be a link that you can schedule time with us. And then we'll also send out a copy of the replay of this in the next couple of days when it becomes available. So if there's something that you want to revisit, or if you feel like it might be beneficial to share with a family member or someone else that you know, could be the one trying to help you through this, then we would love to have that passed along. So with that, I'll say thank you so much for joining us today. I hope that it was good information. It is just the start of a bigger conversation. So we look forward to having that with each of you, and hope that you have a great day.